My lords, my lady, the baton now passes to me to address you on ground 4. Ground 4 is a short point, so as I understand for the short adjournment, I don't propose to detain you for more than a few minutes. The premise of ground 4 is that the appellants have succeeded in persuading you that the relevant provisions of the Limitation Act are not compatible with retained EU law. For obvious reasons, we say we don't reach this step in the analysis. But if we do, then the question arises, by which route should the appellants obtain a remedy? And you heard my learned friend yesterday suggest to you that the proper route is by conforming interpretation. And he took you to the judgment in Vodafone 2. And I'd like to go back there briefly, if I can. So that's located in Authorities Volume 3, tab 38. At page 875 in the bundle. And my learned friend took you to this passage, and he encouraged you to read the well-known statement in relation to the Mar leasing principle at paragraph 37. I want to touch for a moment on paragraph 38, but before we go there, just to be clear, it's not in dispute that the Mar leasing power is what Lord Sumption called a highly muscular jurisdiction in FII. In a situation of this kind, the ordinary principles of statutory interpretation don't apply. However, there is an endpoint or a limit on the application of the Mar leasing principle, and Vodafone 2, in paragraph 38, provides 2 examples of the kinds of circumstances in which conforming interpretation simply isn't open to the court. So the first of them, little a inside the quote there, the meaning should go with the grain of the legislation and be compatible with the underlying thrust of the legislation being construed. And then just over the page, an interpretation should not be adopted which is inconsistent with a fundamental or cardinal feature of the legislation, since this would cross the boundary between interpretation and amendment. The second example given in this paragraph, which is less relevant for our purposes, it is where the interpretive obligation would require the court to engage in policy decisions that it's not equipped to determine. But we do say that the first of those 2 scenarios is squarely engaged in this case. And it might be helpful at this point to turn up the corollary of that principle in EU law, which helpfully we actually find in Eureka itself, at paragraph 93. So this is Authorities Volume 7, tab 81, page 2528. Now, the context for the discussion here is slightly different. What's being addressed is a scenario in which a member state has failed properly to transpose a directive, but it's the interpretive principle that we take from it and we say applies equally here. So it's also apparent from the case law of the court that in a dispute between individuals such as that at issue in the main proceedings, the national court is required, where appropriate, to interpret national law, so this is the interpretive obligation, as soon as the time limit for transposing an untransposed directive expires, so as to render the situation at issue immediately compatible with the provisions of that directive. So that's the interpretive obligation, without, however, interpreting national law contra legem. So that's the EU law equivalent of the first scenario that was set out in Vodafone 2. It must go with the grain of the legislation. It must not undercut a cardinal feature of it. And that brings us to Section 2 of the Limitation Act itself. And that is in Volume 1, at tab 3, page 17. It's very familiar, obviously. We've had it open yesterday. But an action founded on tort shall not be brought until after the expiration of 6 years from the date on which the cause of action accrued. And the critical word within this provision, we say, for these purposes, is the last accrued. That is the event from which limitation for a cause of action runs. And the concept of accrual and the accrual of a cause of action in tort as was pointed out by my Lord, the Master of the Rolls, yesterday, has a specific meaning in English law with a venerable heritage. In tort, it means the date at which loss or damage is suffered. It's also long established that in a case of continuous or ongoing torts, such as in competition law, a fresh cause of action accrues every day. And we heard my learned friend yesterday setting out the words that he says should be read into Section 2 and indeed Section 9 in order to make them conforming. And that was, as I understood it, to add the following words. However, for single and continuous infringements of competition law, the date on which the cause of action accrues shall be on the final date of the infringement. So the nub of my learned friend's submission is that the solution is to be found by amending the means by which a cause of action in tort accrues. And against that backdrop, 5 brief submissions as to why we say that is not a conforming interpretation open to the court. First, the interpolation of those words clearly goes against the grain of the legislation. It requires the word accrue to be lent a meaning hitherto never recognised in English law. Accrue would now mean both A, the cause of action is complete, damage has occurred, and B, in this context, that the infringement has come to an end. But that overturns, we say, the meaning that both the draftsman and Parliament understood the word accrue to bear. That word is a term of art in English law. And on my learned friend's submission, it will now mean something different in one unique statutory context. And in my submission, that's to go against the grain of a provision, or to read it contra lege. And for that reason, we do say it would be impermissible as an act of conforming interpretation. Second, my learned friend's proposed redrafting of Section 2 would lead, we say, to arbitrary distinctions. And MasterCard Skeleton offers a helpful example of a cause of action for personal injury arising from unknown or hidden exposure to a toxic substance. And as with competition law, the exposure may be ongoing. But on my learned friend's construction, personal injury cases would be treated differently to competition cases because the word accrue would mean something different in those two different contexts that would be otherwise relevantly similar in nature. Third, my learned friend's conforming interpretation would put some claimants in a uniquely difficult position. Where the infringement has not come to an end, their cause of action will not have accrued. So the question automatically arises, can they at that point, without an accrued cause of action, issue proceedings seeking damages? We say no. My learned friend's answer to this seems to be that they can still plead the loss that they've already suffered up to that time, but with respect, that's no answer at all, because it makes even more of a mess of the meaning of the word accrue. Because my learned friend's suggestion is that the cause of action won't have accrued, but the claim can nonetheless be issued. Fourth, my learned friend's conforming interpretation cuts across the way Parliament gave effect to the Damages Directive, and that was done not by way of amendment to the Limitation Act, but by way of amendment to the Competition Act. And it may be worthwhile turning that up briefly as well. It's Volume 1, Tab 7, page 67. So this is Schedule 8A, it's paragraph 19, beginning of limitation or prescriptive period. The limitation or prescriptive period for a competition claim against an infringer begins with the later of A, the day on which the infringement of competition law that is the subject of the claim ceases, and B, the claimant's date of knowledge. So the short point is this. Parliament obviously did not consider it appropriate to give effect to the Damages Directive cessation requirement by altering the meaning of the word accrue within the Limitation Act itself. Rather, Parliament suspended or effectively disapplied the alternative open to you, those provisions. And we say that's a very powerful indicator of the proper approach that this court should take if it gets to this point at all. Fifth, finally, the appropriate solution is, we say, to disapply, very much in the way that Parliament did. What that would mean, in practical terms, is that the court would make a declaration to the effect that the limitation period for a competition law claim of this kind would not start to run until the date on which the infringement ceases. That would only apply, of course, as is common ground, in relation to claims issued before IPCD. So by that route, the court would suspend the limitation provision without needing to amend, and we say overwrite, the meaning of the word accrue in English law. If I may pause just for a moment before I come to a close, the respondents do say that the very considerable violence that's done to the English law statutory regime, whether by way of conforming interpretation or disapplication, casts some light on quite how ambitious, and we say unattractive, the appellant's case is. What the appellants seek to persuade you is that you should rewrite or disapply English limitation law as considered carefully and approved in Arcadia, by reference to a judgment of the Court of Justice that postdates Brexit and is on any view a marked development in the state of the law since the United Kingdom left the EU. So if I can put it starkly, the very nature of the exercise that you're being asked to engage in under ground 4 rather shines a light on the magnitude of the hill that the appellants must climb before we even get to that point. And so for all the reasons that you've heard, the respondents say we simply don't get to this stage in the analysis. And on that note, I promise to be brief, but I hope I've honoured that undertaking. And unless I can assist any further, those are my submissions.
Thank you, Mr. Johnson. Yes, Mr. Moser.
My lords, my lady, I have, as my lord the Master of the Rolls has mentioned, put before you 2 documents that we promised yesterday. One was the concession, which I don't plan to say anything further, and the second is our note on the law on issue estoppel. I hope it
I haven't
assists.
looked at that.
Well, I note that neither of my learned friends relied upon the issue estoppel argument.
No.
So unless the court wishes of its own motion to run the issue estoppel argument.
Okay. Well, we'll look at the note, and we don't need to. You don't need to say any more about it.
Well, the essential point is they weren't privies to the
They're not privy.
proceeding.
Yes.
They weren't parties and they weren't privies.
That's right. My lords, that's by way of introduction on the notes. Before I reach the core of my reply, my learned friend Mr. Wolfe, KC, wishes to give the court an update on what he said yesterday.
Yes, I wondered about that.
Yes, I think you asked me shortly before the short adjournment what had happened to the merits case, and I said to you, as I think about 12 or 12:30, it was still ongoing. That was my understanding at the time. Then about 4 o'clock yesterday, Mr. Laney walked into the cabinet and announced that a settlement had been reached.
When I was told what I was told last night, I did laugh out loud actually.
However, just a slight wrinkle on that. That is subject to approval of the settlement by the
Sorry,
Cabinet.
can you just start at the beginning? I don't know anything about this, except my lord mentioned something had happened. I'd like to know precisely what happened and what effect it has on this case. Not just nods and winks and, I need to know.
Yes, my lord. I said yesterday that the merits litigation was still ongoing.
Now, what's the position today?
Yes, and yesterday afternoon it was announced, after I said that.
It was announced by whom?
By, as far as I know, I think MasterCard may have issued a press release. But
who issued a press release?
MasterCard may have done it.
MasterCard.
But Ms. Sonia Delaney, KC, announced to the Competition Appeal Tribunal at about 4:30 p.m. yesterday that a settlement had been reached in principle between MasterCard and Mr. Merrick's regarding the collective action. However, that
and Visa or not?
No, the Visa is not a party to the collective action, solely against MasterCard.
pass-on case is just against MasterCard.
That's not quite correct, my lord.
Right.
I'll come to that in a moment. The case between Merrick's and MasterCard is only against MasterCard.
And how many parties are there to the Merrick's claim?
Well, Mr. Merrick's is there as the collective class representative. Behind him sit 40-odd million UK consumers.
40 million UK consumers.
I believe so.
46 million, I think.
And effectively there is one defendant, which is MasterCard. There may be multiple corporate entities, but it is just MasterCard.
And how many parties are there to the umbrella claimants? How many of those?
There are approximately, I think our client pool consists of about 2,000 companies. There are more who are not instructing me, but not a whole lot more who are sat being not actively possible.
So you and Mr. Moser represent 2,000 companies before us, and the Merrick claim is a claim by consumers,
That's right.
which is that's what distinguishes it from the merchant's claim.
That is correct. Would my lord just allow me to expand upon who is part of the pass-on proceeding?
No, I mean, no. I think the only issue is we only need to know it's a settlement, but it's subject to approval by the CAT, isn't it?
Yes, that's right. It's not effective until that settlement has been approved.
And there's been some articles in the financial press. There's an article in the Financial Times.
That's right. And the funder, as I understand, is
One of the
subject
funders
to-
is complaining. Apparently.
I think that's about as far as I can assist. Unless you.
Okay, thank you very much.
Without wishing to try the court's patience, if I may briefly follow on from that, just to emphasise that the Merrick's claim...
On claim, is it, Mr. Mayor?
Yes, exactly. Well, the Merrick's claim and the umbrella claim are separate in kind and in parties. Merrick's is, as has been pointed out, a collective action brought by a single class representative funded by a funder on behalf of consumers. This claim, the umbrella claim, is essentially 2,000 individual claims brought by my clients who are not consumers. They are at a different level of the chain. They are the retailers. In the CAT, the Merrick's representatives and the umbrella representatives were generally at odds because whichever one of them established whether or not the loss had been passed through would then claim the prize, as it were. So we had conflicting interests in that way. Also, Merrick's was only against MasterCard, as has been established. So these were very different cases, even though briefly, in this aspect of the case, they presented one face to the court, but then they didn't, of course, both take it on to appeal. So very different claims, and I just thought I'd add that.
No, it's very helpful, thank you.
Coming then to my reply, and as an overarching remark, a great deal of what my learned friend Mr. Otti and my learned friend Mr. Solcedo, and indeed my learned friend Mr. Johnson said, was, as it were, the obverse of what I said. I'm not going to attempt to...
That's quite common.
Yes, indeed. But I'm not going to attempt to repeat everything I said yesterday. I'm going to make points as they occurred in order. Yesterday, my learned friend Mr. Otti postulated three kinds of case in relation to sections 4, 5, 6, or as I numbered them 6, 4, 5, because I go in through section 6. And he said, you can have regard to the European Court of Justice, where either, one, it is well in line with previous authority, or two, he said, when the field is empty. But not, as I understood it, where there is previous UK authority. And the difficulty that I submit one ought to have with that submission is that it's not clear in my submission how much is left of Section 6 at all. My learned friend Mr. Otti seemed to go so far as to suggest that you should only have regard if the ECJ confirms the previous case law. But Section 6 is clearly not so limited. It would be wrong, in my respectful submission, so to fetter the UK courts, especially if something has been previously misunderstood about the pre-existing EU law and needs to be put right. Now,
Well, I mean, I don't understand any of that. I mean, if you look at Lipton, it seems to give you quite a lot of hints as to what it means.
well, it hints, but of course Lipton didn't have to grapple with the particular problem that this court has to.
No, but it was very helpful in describing, wasn't it, the whole purpose and effect of the Withdrawal Act. And we're not going to ride roughshod over that, Mr. Moser. That's a bit hopeful, isn't it?
No, and I don't disagree with Lipton, of course, when it says the whole purpose was to withdraw these courts from the supervision of the European Court of Justice. The European Court of Justice does not anymore supervise or direct this court. It is now for this court to decide, as a matter of UK law, what the correct interpretation is. However, I have given you my reading of how you get in the absence of Section 3, how you get in to the ECJ authority via Section 6.2, and that once you've had regard to a case like Eureka, and once you've come to the conclusion, therefore, that is the correct reading of EU law. What is really between me and my learned friends, in particular my learned friend Mr. Salcedo, is whether the ex-tunc, in the words that we didn't like, or rather the phrase that he used, which, sorry, I have it in my notes, but the retroactive principle of EU law is also still part of UK law. That's the real difference between us in my submission. Once, as I submit, it is accepted that the retroactive principle is as much part of the general principles under Section 4 as any other aspect of EU law, then we are, as I said yesterday, back in a situation of applying EU law in pre-Brexit cases like this one, as it ever was. And that includes things like Schedule 1, Paragraph 5, and the points that my learned friend took you to this morning of the EU Withdrawal Act, because we're not talking about a modification of the law. We're talking about a declaratory finding of the European Court of Justice, which I say informs what the law is. Now, your Lordship has also indicated that it might be helpful if this was again put in writing. We're happy to do that, if that is still considered helpful.
Well, I think everybody hates that idea, so I'm not going to pursue it.
For what it's
It
worth.
leads to another round of written
Yes, I think
That's the
we'll
danger.
withdraw that request.
Well,
Mr. Moser.
for what it's worth, and it's worth, of course, quite a lot, I may say this, what your Lordship said at 11:05 this morning seemed to me to encapsulate what I was saying. And so if that can somehow be found in the transcript, that will serve.
11:05.
Yes, well, I made a note of it.
Always a good time.
Yes. My Lord. So my learned friends, both really, unsurprisingly, made the same sorts of submissions around Section 6, 5, and 4. And I didn't, with respect, really quite understand why Mr. Salcedo felt it was all going to ground 2, because in my respectful submission, it does all go to ground 3, as I think was pointed out. And Mr. Salcedo sought to make a point around whether or not the ECJ judgment is going to be binding. Unsurprisingly, that's at the core of what you're deciding. But binding, in my submission, has 2 senses. The first is, we must follow. And the second is, it overrides other authority that would otherwise be binding. And I submit the two have become slightly confused. We are not saying the court must follow because of section 6.1, but we are saying the court can follow because of section 6.2. And then we are, in the way that I've described, in an area where the court can proceed notwithstanding Arcadia. But if the court chooses not to follow that, it should, in my respectful submission, articulate its reasons for not doing so.
So that assumes that the court has a discretion as to whether or not to apply it to comply with the doctrine of precedent. Because if the doctrine of precedent still arises, then we are bound by Arcadia.
Because he says you've
Which depends
misunderstood.
where you start, doesn't it? Depends where you start. If you start with that proposition, which is a perfectly it's not a heterodox proposition, it's an orthodox proposition of English law, then you would say, turning to the European cases which aren't binding on us, as you accept, should we follow them and effectively disregard Arcadia? There's quite a strong case of saying we shouldn't do that because we're not allowed to. And even if we were allowed to, we shouldn't do it because it's not an appropriate orthodox approach.
I mean, in my respectful submission, there's a danger in viewing the test and in viewing section 6 so much through the prism of Arcadia and what's happening in this case. It's understandable, of course. But if one tests the point by asking what relevance this would have if there were no Arcadia, or if we were now in the Supreme Court, then the point disappears because there's no issue around precedent.
If you look at it through the prism, if you don't like looking at it through the prism of Arcadia, I follow that. But if you look at it in the context of what's said, it's not just Mr. Davis, I think it's somewhere in the explanatory notes, that it's effectively going to be akin to whether this court has regard to Australian authorities, say. The one thing this court would not do if it was referred to as a decision of the High Court of Australia, which was contrary to a previous decision of this court, is to say, we'll follow the High Court of Australia and disregard the previous decision of our own court.
And that's where I respectfully differ from what Mr. Davis said in Hansard, because we are in a somewhat different situation, because we're not in a situation where until the end of 2020 we were entirely governed by Australian law.
No, I follow that.
And so,
But can I just put to you, I think this is all the same point, but I just want to put it into the debate. Mr. Salcedo explains that you completely misunderstand the original 1972 legislation as to what was being given precedence when the waters flowed up our rivers, as Lord Denning, I think, said. And all that was being said there was that the doctrine of precedent continued quite as uninterrupted by those flowing streams, except where there was a decision by the European Court, the Court of Justice of the European Union, which overruled or contradicted or was inconsistent with that presidential decision in English law. It is not a case of there being some supremacy to EU law generally in some sort of great big morass. And in fact, that's not surprising because it's actually only recently, I think, that the principles of European law that we now talk about so fondly, effectiveness and equivalence and legality and certainty and all those lovely principles, have become so prominent. Because, you know, when I was young and learned European community law, which was in the 70s, it was really completely different, and it didn't encompass all those principles. So he says you just misunderstood it. And once you understand the doctrine of precedent, it's obvious we've got to follow it. You may be right that without Arcadia, and if we were in the Supreme Court, test it that way, even with Arcadia, we'd be having a very different debate. But you have to get over the Arcadia first, for us.
Yes, and my learned friend did that, if I may say so beautifully, by reference to Section 3.1 of the European Communities Act.
And what's the answer to that?
Well, the answer to that is that Section 3.1 is not essential to the point. And I respectfully disagree with my learned friend on that point. If we look back at the Act.
I mean, just before you do it, by all means, but where is the case in the last, 52 years that says that you have regard to some pre-existing principle of European Union law when a national case has decided what EU law is and applied it finally?
Well, the short answer is Elkinov, but I'm going to, which has been mentioned by my
I don't think Elkinov
learned friend. Well, we'll come back.
We'll have to look at that.
We'll come back to that. But
Okay.
I want to give, if I
Section
may,
3.
I want to give, if I may, a fundamentalist answer.
Yes, well.
Because what has been the case ever, or was the case ever since entry, and the 1st of January 1974 until, to all intents and purposes, still the case for cases governed by EU law, is that EU law was supreme. And although it may have taken different courts and different member states more or less time to appreciate quite what that means, I would argue that even in the 1970s, it was clear that that included, for instance, the need to set aside any national law that conflicted with EU law.
Yeah, only when the Court of Justice had said what EU law was.
Exactly. I mean, if you'd had a case in the 1970s or 80s where the Court of Appeal had said what EU law was on a particular issue, forget this issue, then if you were then in the Court of Appeal 2 years later or 5 years later, no point arguing that that first Court of Appeal decision was wrong in its interpretation of EU law, because the second Court of Appeal would be bound by it. So if there was a decision of the European Court in the meantime, that's a different point, because then, as my Lord says, our system of stare decisis was amended so that the European Court became the Supreme Court on issues of EU law. But if there wasn't a decision of the European Court, you couldn't go around saying, well, ignore that case because it got the EU law wrong.
Well, it didn't have to be. I mean, it didn't have to be a decision of the European Court. It could be any rule of EU law.
I'm not sure that's right.
But you see, we had lots of people in this court only 2 weeks ago for 7 days, including Ms. Patel, where it was argued that in a case called Prestige, that Mr. Justice Hamblin, as he then was, and the Court of Appeal had decided a point of EU law, which, notwithstanding that the Court of Justice, in what was said again to be an extravagant exercise of its jurisdiction, had overruled and said was completely wrong, we had to follow because it was raised judicata, because he had decided the point of EU law, it was said, and we haven't given our judgment, so I have no idea what we might be saying about that, but that was decisive as to the point of EU law, and that I don't think that was actually disputed in the case, that it would be if it were. Right?
Although it's raised judicata rather than binding.
Yes, it's raised judicata, but I mean, it's still, it's the same point, really. Is that
we know that, for instance, even a statute of Parliament had to be set aside in factotem because it was found to be conflicting with EU law. And at the time of factotem, everyone said, well, this is an extraordinary departure. We had no idea that EU law could do this. But actually, those who had studied EU law, and as your Lordship will be aware, will have been aware of the case of Simmental way back in the 1970s that had said essentially the same thing. It just sometimes took a while for the full force of this to be appreciated. And if we look at...
Well, let's look at Elkin.
Elkin.
Let's look at it. It says what you say it says.
Where's Elkin?
Yes, and my learned friend Mr. Wolfe quite rightly points out that Costa and Enel said much the same thing, was in 1964. But let's not go back to 64. Let's look at Elkinov, a more recent authority in 775. Tab 75, bundle 7. It starts at 2,312. My learned friend, Mr. Otti, I think took you to it, or at least he made submissions about it. And the relevant part of Elkinov starts at paragraph 29. And it talks about what is settled case law. This is 2011. Settled case law that a judgment in which the court...
2348.
Forgive me.
Page 2348.
Yes, page 2348. I'm grateful.
29.
29.
Settled case law.
Settled case law that a judgment in which the court gives a preliminary ruling is binding on the national court as regards the interpretation or the validity of the acts of the European institutions in question for the purposes of the decision to be given in the main proceedings. And it cites many judgments from the 60s through to the 2000s. It follows from those considerations that the national court, having exercised the discretion conferred on it by the second paragraph of 267, because that was the issue in the case, it will be recalled, for the purposes of the decision to be given in the main proceedings by the interpretation of the provisions at issue given by the court, and must, if necessary, disregard the rulings of the higher court if it considers, having regard to that interpretation, that they are not consistent with European Union law. So that's the first point, which is that the lower national court is not bound by the higher national court if it's not consistent with European Union law.
If it's not consistent with the decision on the reference as to what...
But then...
European
The case law, I mean, paragraph 29 actually refers in terms to the case
It does, but then I read
of the
on.
European Court, in other words.
Indeed, but then I read on to 31, which my learned friend Mr. Otti did not take you to. In addition, it says, it is appropriate to point out that in accordance with settled case law, a national court which is called upon, within the exercise of its jurisdiction, to apply provisions of European Union law, it's not limited to case law, I add, is under a duty to give full effect to those provisions, if necessary, refusing of its own motion to apply any conflicting provision of national legislation, that is to say, in the present case, the national procedural rules set out in paragraph 24 of this judgment, and it is not necessary for the court to request or await the prior setting aside by legislative or other constitutional means. And they cite, amongst other things, Amministrazione delle Finanze dello Stato and Simmental from 1978. And that is, of course, the well-known case in which the court said that a national court called upon to apply provisions of EU law is under a duty to give full effect to that provision, if necessary, refusing to apply conflicting national law. That's Simmental. And all of that is in response to the third question, which is referred to as paragraph 24 on page 2347.
The third question.
The third question, which is the third referred question, and it's set out in paragraph 24 of the court's judgment at 2347, where the European Union law precludes a national court which is called upon to decide a case referred back to it by a higher court hearing an appeal from being bound in accordance with national procedural law by legal rulings of the higher court if it considers...
Sorry, that's unintelligible sentence. What does it mean?
It means that EU law in this case trumps national procedural law.
Includes a national...
And it's a rule of precedent because it's a 2011 case. though this court is bound by it unless it were able to depart.
Well, if it considers, having regard to the interpretation which it has sought from the court, that those rulings are inconsistent with European
In law. But of
about-
course, the reasoning then goes wider because, as we saw in 31, there is a general duty of the court to disapply national provisions that conflict with EU law.
I mean,
But this context is exactly right. My Lord's just pointed out. Go to page 2346 and look at question 3. This is dealing with the situation where the court has referred the matter to the European Court for a ruling under Article 267 and basically been told to do its exercise again where there's a reference back. So it's dealing with references to the European Court. So it's dealing expressly with the situation where the European Court has said, no, your higher court has got the law wrong, got the European law wrong. It's not dealing with some general principles of EU law for which there's no existing European court decision. That it's not saying the national court just thinks to itself, well, I think the Court of Appeal in Arcadia got European law wrong, so I'm just going to ignore it and reach my own decision. That's not the position.
where do you get to, as Mr. Salcedo said? The next day after Acadia, a first instance judge hearing another case can say, oh, well, European law is not what they said in Arcadia, it's something completely different. And it's act clair, in my opinion, and therefore I'm going to decide I'm not bound by Arcadia. I think that's nonsense.
Well, I submit that would have been the correct EU law position before Brexit. If you had a very brave first instance judge. In reality, the first instance judge would probably have referred. And that's the situation that sometimes occurred.
Well, that's
just
just
a
point
risk.
though, isn't it? The first instance judge would have been able to refer if they really thought that.
Yeah, but a judge who didn't refer and didn't get a ruling from the European Court in as it were, in favour of his or her views, could not simply have ignored Arcadia. I mean, that's a recipe for complete anarchy.
Well, she would have been in danger.
Certainly would.
I think that's maybe a use of the feminine gender which could offend the court.
or he. Just picking up on, but that doesn't make it wrong. You apply the law, ruant coli, as it were, to use another.
I don't know.
Well, and the heavens may fall.
What?
You apply the law, whatever the consequences.
Oh, right. Jolly good.
So, but the gist of that, my lord, is that I take issue with, however beautiful, the technical point my learned friend raises about Section 3.1 of the European Communities Act. Because I say that Section 2 of the European Communities Act gets me home via Simmental and via the principle of supremacy, so that it is still also a question of supremacy when we're dealing with my interpretation of sections 6, 4 and 5, notwithstanding the fact that section 3 has been repealed.
So section 2 gets you home via Simmental and...
there are two section 2s here. So section,
Come off.
section 2 of ECA.
section 2 of ECA, which is still referred to in the relevant part of the UA 2018.
And Elkanah.
So that gets me home via the three sections that I've relied upon. So we have
Yes.
we have section 6.2, where subject to this and subsections 3 to 6, a court or tribunal may have regard, and we have section 4, which is the rights, powers, liabilities, obligations, restrictions section, by virtue of section 2.1, would have been recognised and available by virtue of section 2.1 of the European Communities Act, and I say I have enough within the EU law that flowed into UK law up the rivers or howsoever through the conduit pipe under
So
Section 2.
you're really saying that, are you saying that Section 3 of the European Communities Act wasn't really necessary? Because that rather contradicts what most people have said about the drafting of that legislation.
It wasn't necessary under EU law. Clearly, the UK legislator thought differently, and perhaps that's not surprising, because it was always an extraordinary thing, and we saw that in the factor claim legislation, to be told that, well, actually, you're obliged to follow this, regardless of precedent, regardless of what Parliament has said. And so it's entirely understandable why the European Communities Act was drafted the way it was. But looking at EU law, looking at the constitutional position under pure EU law, Costa and ENL, Cimentar, and then factor claim itself in Luxembourg, I say it's clear that Section 3 wasn't in fact necessary. Once you've had EU law with its principle of supremacy flowing into UK law through the conduit pipe of Section 2.1 of the European Community, you had all of that flowing in, as Lord Denning himself observed. He later used a slightly stronger language about it, flooding the fields and the houses. But that was the effect. That was the effect.
You referred to 4.1 again, back to the Withdrawal Act. Mr. Salcedo, who's not a man who, in my experience, fails to understand many things, if they're put clearly, failed to understand your argument on Section 4.1, and I'm not sure I put it to him adequately. Could you just remind us of why 4.1 helps you?
Well, because in my submission, once you've had regard to the European Court in Falk and Eureka, or indeed on, as I say, my reading of Manfredi and how the Advocate General read Manfredi, once you've had regard to what EU law actually was before exit day, properly interpreted, I say we are back within the rights, powers, liabilities, obligations, etc., that have been saved by the European Union Withdrawal Act 2018 in respect of pre-IPCD matters. And those rights, powers, liabilities, obligations, restrictions, remedies and procedures, which, yes, he is quite right, flowed into domestic law by virtue of Section 2.1, continue on and after IPCD, so now and today, to be recognised and available in domestic law, and to be enforced, allowed and followed accordingly.
So it's because it's a right under EU law that, though not, well, you say declared by Manfredi, but anyway, a right under EU law that existed all the while from before Brexit Day and after Brexit Day, even before declared by Volvo and Eureka, it is a power that is preserved in EU retained law, whatever it's called, retained EU law, and becomes part of English law. So that principle is part of English law, which we're bound to apply.
Yes.
And then how does, I see, and notwithstanding, of course, that if Eureka was new, we're not obliged, we can only have regard to it.
We're not bound by it.
Not bound by it.
Bound by, but
You say that doesn't matter because Eureka wasn't new.
So every
That's your
single
whole point.
decision of the European Court that develops European law until time ends or another statute is introduced by another government means that the EU law, as it was on exit day, is taken to be whatever the European Court says it is at some stage in the future, in 5 years or 10 years or whatever. I mean, that's the consequence of your submission.
Well, only if you're persuaded by it.
Well,
Not by my submission.
Most submissions, Mr. Mason.
Not by my submission. If you only if you decide to follow it, so you have the discretion to follow or not to follow. But once you follow it, everything flows from that.
Well, I thought your whole point was that European law on this issue that we're dealing with, from the beginning of time, is what is set out in Volvo and Eureka.
Yes.
And therefore we're bound to apply it because it's actually under Section 4, which is a submission you just made.
Yes.
In answer to my lord, it is and I'm not sure which of it is. I mean, whether it's a right or a remedy or whatever. But whatever European law is now held to be was always European law, and therefore we have to apply it because it's now part of English law.
Yes, of course, only because of EUR. It's been saved by the Act only in relation, for present purposes, to matters that occurred pre-IPC-D. And, of course, there's another statute introduced which has sunsetted all of this in 2023. So there's not the not the danger that your lordship envisages.
The further caveat, as I understand it, is there is an additional hurdle that we somehow have to persuade ourselves that Eureka is actually correct in declaring EU law. That's how you seek to get around Section 6.1.
Yes.
You say we can have regard to it, and if we determine it doesn't correctly reflect EU law, then we don't have to follow it.
No, Tower Bridge.
But the... Yes.
But then Eureka...
How we go about that exercise is...
I mean,
that's straightforward.
But
the sunsetting point is what an attempt to avoid a floodgates argument. and you also presumably answer Mr. Salzezo's points on Section 5 and Schedule 1 by saying that if you're right, this was always EU law, whatever anybody may have understood it to be, because of Manfredi. None of those paragraphs, however much they give a sort of colour, don't actually say that any principle of EU law later declared is excluded.
Indeed.
Yeah. I mean, they go very close to it, but they don't quite get there, you say.
Yeah.
As my lady pointed out repeatedly as we went through Schedule 1, including to the last paragraph 5.
Yes.
Mm.
Yeah. Okay. See that?
So that is where we are. And for the sake of completeness, when Section 4 talks about rights, powers, liabilities, obligations, restrictions, remedies, procedures, and every word one can think of, my reading of that, and the reason I haven't nailed it down with particularity, is that the attempt in Section 4 is precisely to cast it as wide as possible, so that whichever measure one might care to imagine will fall within one or more of those words in Section 4. It's meant to be a sweep up of all that EU law that flowed into UK law before Brexit. And my learned friend mentioned the case of O'Byrne. I don't want to go back to it, but that doesn't contradict that, because in that case the court said that the ECJ didn't apply. The ECJ case didn't apply on the facts. So that was a case where the ECJ case was simply distinguished, and that doesn't, in my respectful submission, assist. So my final step, of course, remains, and it's the step I've sought to ground in supremacy in Section 4, which is that amongst the powers, etc., that pre-existed, once the court has decided on the correct interpretation of EU law, is precisely that power to set aside or ignore previous conflicting national decisions if they're wrong under EU law. So that's how I get to where I need to get to. Mm. And I've pointed out that I say I get there either via Volvo and or Eureka, or indeed one of the previous cases that were decided before Brexit, Krian, Manfredi and Kogiko, or however one wants to pronounce it. I want to pick up some of those cases, particularly in relation to Eureka itself. My learned friend Mr. Otti earlier today made his submissions about those cases. I just want, before I reach Eureka, I want to touch on a point that was mentioned in relation to Volvo, and I think it was in an exchange between the Master of the Rolls and Mr. Otti that it was mentioned. We needn't turn it up again, but it will be recalled that in paragraph 28 of Volvo, it was already said that there was a dramatic extension that had occurred. And so to that extent, it's difficult to...
No, that was what was said by CAT.
CAT, yes.
Paragraph 28 of its judgment about Volvo.
About Volvo, exactly, yes. Sorry, I put that, that's what I meant to say.
Yeah.
And so I just picked up on that remark because I submitted a neat encapsulation of why Eureka is not a surprising and dramatic extension anymore, because the CAT, with whom of course we don't agree in every respect, but as a matter of historical fact, the CAT recognised pre-Eureka that what it thought was an extension had occurred. So to the extent, if I'm wrong and Volvo Eureka are extensions, I just wanted to nail down the fact that the extension certainly had already occurred no later than Volvo.
I'm not sure that's quite what it said, because what it said was, actually Volvo didn't decide any of this in the dispositive, but if we're wrong about that, it would be a surprising extension.
In any event, how does that help you?
Well, that's because they sidestepped.
Veer off in the wrong direction on this hypothesis.
They sidestepped the obvious reading of Volvo by their insistence that you have to look at the narrowest basis, which is what is necessary for the dispositif. And that's why I say I don't agree with everything the CAT said. Anyway, I didn't mean to go to dive back into the CAT judgment on this. I simply wanted to pick up on the fact that by the time we've reached this case and we've reached Volvo, Eureka should have been not very surprising in my respectful submission. But we then had Eureka, and it is right to say that in Eureka, the Commission argued essentially the point that my learned friend was making, to say that, oh no, this ought not to be read as being a case where the cessation requirement has to be read in. And if we can turn to Eureka now, that's at 70, sorry, it's at
81.
81. Bulk Bundle 7, starting at page 2480. And my learned friend took your lordships to paragraphs 98 and 104 of the Advocate General, which is at page 2504 and to 2508. And that is where, of course, the Advocate General mentions her route to the opinion, to her conclusions, starting with Manfredi at 98 and 99, my learned friend mentioned, and at 100 to 103 is mentioned the Commission argument made by my learned friend Mr. Khan KC, that this was a new legal reality. And as my learned friend pointed out, at 104, the Advocate General says that line of argument cannot, however, be accepted. But he then says, oh, that was never developed. In defence of Advocate General Cocotte, I would like to point out that it was very much developed, because she then says at 105 following what she says in support of her arguments, and in particular at paragraphs AG 114 through to 124, the Advocate General explains her reasoning. My learned friend Mr. Wolfe also wants me to point to 113, I think. Is that what you... Similarly, it is essential that limitation period, this is at 113, be allowed to elapse before the infringement has ceased, not be allowed to elapse, forgive me, before the infringement has ceased, in order to protect the right of the injured parties to be compensated in full for the harm suffered, which is part of the body of case law established prior to the directive. And then there's a reference back in 54 to Manfredi and another case called Manuel Ferrer. And then the arguments continue. There is at 116, the reference that I took you to in opening, to the twofold requirement, 3 lines down, page 2507, the twofold requirement of knowledge of the infringement at the end of that infringement allows the starting point of the limitation period to be determined precisely and reliable, in particular the case of actions further to a decision of a competition authority, and so on. And I've taken you to 117, 118, and that's how we reach the conclusions at 123 and 124, precisely mentioning Manfredi. And that's the phrase I've said several times, and I'll repeat it once more, that Manfredi, in the words of the Advocate General, is perfectly transposable to the present case. So I respectfully request the court to accept not my learned friend's interpretation, or even necessarily mine, but that of the Advocate General of the Court of Justice in saying that Manfredi is so transposable, for all the reasons that she has set out from paragraphs 113 to 123. So much in defence of the Advocate General. And we then have the rather surprising submission that Eureka might not be stating EU law even now. And I do want to, I know this didn't particularly go down well with the court, but when my learned friend Mr. Salcedo made the point, but I do want to point out that whatever else one says about Eureka, I submit there can be no doubt that at least in the EU sphere, in the EU jurisdiction, this is now the law. And in addition to all of the paragraphs that the court debated with Mr. Salcedo, there is of course also paragraph 55 at page 2522 of the main judgment, where it said it is apparent from the case law that the exercise of that right, the right to claim damages, would be rendered practically impossible or excessively difficult if the limitation periods applicable to actions for damages for infringements of the provisions of competition law began to run before the infringement came to an end, and, there we have that word "and" again, the injured party did not know, or could not reasonably have been expected to know, the information necessary for bringing its action for damages. And then we see similar points, as was pointed out by the court, made in 59, in 63. So the first point is there can be absolutely no doubt that as far as EU law now is concerned, that is what the ECJ has determined it is. It's binding on all the member states, and it's going to be applied in any case that applies EU law. I then, of course, have to persuade the court to take the extra step to find that it was always EU law, properly understood, and I've made my submissions on that, and I'm not about to repeat them.
Well, the only thing you need to answer is Mr. Otti's submission that Manfredi and the other 2 cases, Creon and the one we can't pronounce, Cogito, did not ever say that it was a necessary feature of the EU law principle of effectiveness that there should be a cessation requirement.
Well, as your lordship observed, those are all cases in which the CJ stuck to the self-denying ordinance of saying that ultimately it would be a matter for the member states. But as I attempted to explain in opening, whenever in those cases the CJEU used its well-known coded words as to what the law is, what in truth it was saying was that you have to give the full effectiveness of the law in such a way that allows claimants to claim all of the damages, and that means from the beginning, in order to give completely the full effectiveness of EU law. And that was my reference in opening to paragraph 26 of Courage. Of course, my learned friend is right. Courage was about something very different. But it's the starting point for the full effectiveness of Article 101, as it now is.
So what you say is that it's the word that they repeat several times, that you can't have a partial claim, you have to claim all the damages,
Yes.
that imports by code the cessation requirement.
The words full effectiveness.
Full effectiveness, yes.
Full effectiveness, as explained by the Advocate General in Eureka, that the full effectiveness means that you have to be entitled to bring your whole claim and to be compensated for all of it. It's not monstrous or unusual, and we've seen other cases.
It's sort of monstrous, a bit monstrous and unusual, because the difficulty is what happens, again as pointed out this morning, if somebody wishes to claim a lot of their damages, the defendant is about to go bust and wants to bring proceedings to get 90% of their damages, or as much as they can get now, if the cause of action has not accrued. And the thing that seems to me to be problematic is that no cause of action at all arises until the cessation of the infringement. I mean, we discussed this briefly yesterday, but it does strike me as really difficult.
But if you've got a whole series of causes of action,
Yeah.
accruing over the period of the infringement up to and including the end of the infringement, it's a matter of English limitation law. You are able to pursue those causes of action. You may not be able to pursue them all at the outset, but at some stage you're going to be able to pursue all of them in order to get the full amount of your damages, which gives effect to the principle of effectiveness.
Yes,
Even though you can't claim it all at once.
including by being able to amend your claim as you go along, which is a further feature of the English legal system.
Well, I'd come back to that.
Which is the point that Sir Terence Atherton makes in Arcadia.
Well, I'd come back to that in a moment, and also in answer to what my learned friend Mr. Johnson said. But just to complete the thoughts in relation to those authorities, those three authorities. Probably the high point of this, I recognise, but it is paragraph 79 of Manfredi, which talks about 2285, bundle 7, tab 72. And it talks about...
Is it 2285?
2285, yes, paragraph 79. And I'll address it first just in relation to the cessation requirement, and then I will come on to the continuous or repeated point. But where there are continuous or repeated infringements, it is possible that the limitation period will expire even before the infringement is brought to an end, in which case it is impossible for any individual who has suffered harm after the expiry of the limitation period to bring an action. Now, I've said one thing about this paragraph before, and the one thing I said about it was that it contains in embryo the argument that there has to be a cessation requirement. And that is certainly how the Advocate General herself.
Indeed, but I tried to make this point before. 79 starts in such a situation. That seems to me to refer back to 78, which is
Yes.
dealing with the specific situation where the limitation period runs from the date on which the agreement or concerted practice was adopted. I can understand the point at the end of 79 in that context, but I find it much harder to apply it in the context in which it is then adopted in the later case law.
Or apply it in the context of the English law of limitation.
Indeed.
Where it does 79 in the context of the English law of limitation seems to me to make no sense at all. It's dealing with the situation of the short 3-year Italian limitation period that began on the day when the contract was entered into or the agreement was made or whatever it is. And I can quite follow the point then that it might have expired before the infringement had ceased. But that's not the case in English law at all.
But perhaps I can help, because my interpretation of that is that the cessation requirement, as an EU point of limitation law, is supposed to be enabling, it's supposed to be permissive. That in situations, as described in Manfredi, where you've had the continuous or repeated infringements arising, and they've ended before anyone's brought an action, and then perhaps the year has expired, and then before you even know what has happened, you have lost your right to bring a claim. In such situations, you have to have both cessation and knowledge. But in my interpretation of the EU law on this point, it's not meant to be a preventative application also. So it's not that unless it has ceased, a national limitation period is not allowed to start running. We deal with that in the Marleasing point in response to Mr. Johnson's argument. Our construction of the Limitation Act includes to say, well, where it's still ongoing, as indeed it is in this case, you can bring your claim up to the date of issue under our national law. So that the cessation requirement isn't, as it were, an essential ingredient of your cause of action in ongoing cases.
I mean, it seems to me, Mr. Moser, however one reads 78, 79, 80, 81 of Manfredi, they weren't seeking to impose a cessation requirement in relation to every single limitation regime in every single member state, because 80 is the clue. It is for the national court, that's the Italian court, to determine whether such is the case. In other words, whether what we said in 78 and 79 is correct with regard to the national rule at issue in the main proceedings. So that's the Italian rule. So this is not laying down some, 79 is not laying down some general proposition that you have to have a cessation requirement to give effect to the principle of effectiveness.
No. But then you have, of course, Eureka, where they do
well,
it.
I know, you will know the point that my Lord put to you is that you have to satisfy us on this part of the argument. And I follow your point that Eureka effectively lays down what the law has always been for all time. But you, at least on one part of the argument, you have to satisfy us that the earlier case law laid down that there was a cessation requirement.
Yes, and
the closest you get to it, and I think you fairly accepted, is 79 of Manfredi.
And your Lordship is right that they don't go on in Manfredi to say what your Lordship says. However, what they do say is it's then for the national court to decide, and you are the national court, and so you then go on and decide what that means in relation to our limitation system.
Yeah.
And that is now informed by having regard to Eureka.
Yeah. Okay.
And that is probably as far as I'm going to take Manfredi. That really brings me, I think, but let me check, to Mr. Johnson's arguments, which I've I've essentially given a sort of preview of my response to Mr. Johnson, and I can do it relatively swiftly. I just, if I may, I'm going to pick him up on one thing he said. If we can just turn to tab 38, so bundle 3, tab 38 was the case he was addressing, the case of Vodafone 2, and the passage I also took your lordships to your ladyship yesterday at page 875. And it's a small point, but my learned friend said that these are just examples at 38. Well, they're not examples because what...
So which paragraph?
Paragraph 38.
38.
At 875.
Yeah.
Just for the sake of accuracy,
Yeah.
they are the only constraints on the broad and far-reaching nature of the interpretative obligation. And the only one that he relied on was to go with the grey. And he picked up on accrual and when the cause of action accrued. But we have addressed this point in our skeleton argument. And in our skeleton argument, we pointed to the case of Paragon Finance. That is at bundle 2, tab 30. Starting at tab 30, starting at page 572.
Yeah.
Court of Appeal case about solicitors who had acted for both the plaintiff and the borrowers. I suggest the facts don't need to detain us, but what it did contain, what we point out in the skeleton, is that it has a definition of cause of action. So what has to accrue is a cause of action. And that's 577, internal page 405. Between D and F, Lord Justice Millett dealt with the classic definition of a cause of action given by Mr. Justice Brett in Cook and Gill, 1873. Cause of action has been held from the earliest time to mean every fact which is material to be proved to entitle the plaintiff to succeed. Every fact which the defendant would have a right to traverse, my emphasis. The emphasis was material, which is material to be proved. In the Thackeray case, Mr. Justice Chadwick cited the more recent definition offered by Lord Justice Diplock in Letang and Cooper and approved in Steamship Mutual Underwriting. A cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. I do not think that Lord Justice Diplock was intending a different definition from that of Mr. Justice Brett. However it is formulated, only those facts which are material to be proved are to be taken into account. The pleading of unnecessary allegations or the addition of further instances, etc., and the pleading points are made. That is what needs to accrue. And we see that under our system, rather beautifully, cause of action is a wide concept, the factual situation, the existence of which entitles one person to obtain a remedy against another person. And I repeat my submission from yesterday that there is nothing to stop a comfortable, conforming interpretation of sections 2 and 9 of the Limitation Act, where the factual situation is an Article 101 case. And in deference to EU law, includes the fact that the infringement has ceased, or where it's ongoing, that the cause of action includes a situation where it is being issued during the continuing infringement to the date of issue, which are the two ways that we've put it in the skeleton argument. And there's no need to read across to personal injury cases or the other matters in terrorem that my learned friend raised. So, my lords, that's all I have to say in response to conforming interpretation. As for disapplication, well, it seems that happily we agree, which is a nice note on which to end. And my lords, unless I can assist the court further, I was proposing to leave it there.
Well, thank you, Mr. Laser. Thank you. Well, thanks to you all for the expeditious dispatch of this case. We won't use the remaining 55 minutes to deliver an extempore judgment, although that would be attractive as well. We'll reserve our judgments and hand them down in the usual way. When we do, they are to be used only for the purposes that involve drafting an order and agreeing costs. In every other way, they are to remain confidential. And if you have any arguments about questions of costs or the order, we'll deal with that in writing in the usual way. But thank you all for what certainly has been an interesting argument.